I'm Dorothy Doherty, the Programs Director here at the National Archives. We have records that date back to 1685. They actually predate the federal government. Most people come to do their genealogy research here, and so we have a lot of people using our computers. We have free access to Ancestry and a number of other subscription services, but you can also access our textual records and do original records research as well. So I invite you to go do some research, and if anyone is interested after the talk, I'm sure Nicole will mention this, but we will give a tour of our special projects room, and we will be pulling out our special roll of attorneys that has Alexander Hamilton's signature as well as Aaron Burr's signature on two separate lines.
Fran Chalet, president and founder of the Alexander Hamilton Awareness Society, or for short, the AHA Society. We're celebrating Hamilton 2016. Thank you all for being here. We're very excited to have POOJA NAIR back, as she's been a featured speaker at Hamilton's home, at Federal Hall, at Museum of American Finance. So we're just very fortunate because POOJA NAIR works for Foley & Lardner, a very prestigious law firm, and she's based out of the Los Angeles office. And POOJA is also, we're very excited about the fact that she is really focusing on research for hopefully books in the future about Hamilton's law career. So very, very special to have POOJA NAIR, so let's welcome her for her talk.
This is a story about Alexander Hamilton and the evolving relationships that he had with other members of the New York bar. In other words, other attorneys that practiced with him, and the alliances that they had, how they shifted, and how these relationships affected New York jurisprudence and the future of American jurisprudence. So after the American Revolution, the courts in New York and across America were facing challenges arising from the split with England. The practice of the courts had always derived from English common law and also been influenced by English statutes. So with the American Revolution, courts were left with several unanswered questions. The main thematic that they were struggling with was how much they should keep the precedents of the British legal system versus adopting a new path for the newly free American states. James Kent, who was a prominent jurist and New Yorker, wrote about this time period in the 1780s and 1790s. We had no law of our own, and nobody knew what it was, meaning that the courts were, in his opinion, in the 1780s and 90s, in complete chaos. This was a little bit of an overstatement. I think that the courts, especially in New York, had a history of keeping their own precedents and forging a little bit of a different path than the British courts. But James Kent's view was that at this time period, there were a lot of unanswered questions for the courts and for lawyers. So into this comes the New York bar, members of the New York bar. By bar, I mean the Association of Lawyers in New York. Now, something happened during the war in which the people who would normally be studying for and practicing law obviously were absent, mostly serving in the Continental Army during the Revolution. So prior to the war, we had a requirement that was a 3 to 5 year clerkship requirement, meaning that in order to practice law, you had to be apprenticed with a lawyer for 3 to 5 years while you were studying, and then you would have a kind of a bar examination that was an oral exam that you would have to show how familiar you were with the law and show your fitness for practice. But because so many people were away during the war, and if they had kept that requirement, then they would have prevented a whole generation, essentially, from practicing law. The New York bar decided to suspend that requirement. So people who had served in the Continental Army could apply for an exemption, which Alexander Hamilton and Aaron Burr did, based on their wartime service, and then they would have to study on their own and be able to reach the level of legal expertise that they would have achieved during a 3 to 5 year clerkship with a practicing lawyer. So I'm going through the New York bar through the lens of Alexander Hamilton, who practiced in the bar from 1782 until 1804, obviously with time that he was away from New York running the country's finances as Secretary of Treasury. But Hamilton's cases covered a wide variety of topics, and he interacted with a lot of people. But I'm focusing on 4 people today that were Hamilton's contemporaries at the New York bar, and were people that he interacted with in many of his most prominent cases. So first, I'm talking about Brockholz Livingston. Now, Livingston served as the aide-de-camp to Hamilton's father-in-law, General Philip Schuyler, from 1775 to 1777, and was also an aide-de-camp to Benedict Arnold. So Livingston returned from his wartime service and actually joined the bar in 1783. And he was an extremely prominent criminal defense lawyer. So he handled murders, rapes, assaults, like he was kind of the Johnny Cochran of the time. Anytime there's a prominent case that's in the newspaper and I look and see who the defendant's lawyer is, it's pretty much Brockholz Livingston, assuming that the defendant was rich. But he's quite a character and he comes up a lot. So another person who's actually younger than Hamilton and wasn't part of this Continental Army crowd, but is pretty important, is Cadwallader D. Colden. So Colden was away from New York during the Revolution. He actually studied in London, but he returned to New York in 1785, and he studied during like the normal course. Didn't get an exemption because obviously he was not here for the war, and he joined the bar in 1791, so about a decade after Hamilton, Livingston, and Burr. And he actually was assistant New York Attorney General, meaning that he was a prosecutor in a lot of these cases where some of the others that we were talking about were defense attorneys. Aaron Burr was admitted to the bar in 1782. He also had an exemption and did self-study because of his military service. He was appointed New York Attorney General in 1789, but this was kind of brief, and he ended up serving as a U.S. Senator. But his law practice was always extremely lucrative and very important to him. He did several types of cases, business, he did litigation, and he did just a wide variety of cases on both sides. And his style of being a lawyer was praised as being very, very succinct. Someone said of him, I think it was James Kent, said of him that Colonel Burr could say in 5 minutes what would take someone else several hours to express. So he was not known for being extremely eloquent or holding the attention of people for a long time. He was known to kind of get down to the point and make an argument in very little time that was convincing to the jury. And then, of course, Alexander Hamilton. So he started studying for the bar in October of 1781. He completed the course of study in somewhere between 3 and 6 months. And it took most people several years to get through the course of study, even without the clerkship requirement, because there's a lot of material that you were expected to know. He wrote a book for himself, basically, while he was studying, that was called The Practical Proceedings in the Supreme Court of the State of New York. It's essentially a practice guide. It's Hamilton writing notes on how law works in New York. And it's actually the earliest known treatise on the practice of New York courts. Then Hamilton's legal career covered several different areas. He handled contract law, trust and estates, land disputes. He did a few criminal law cases, and he did insurance. It was a huge spectrum of cases. That was true for all of these attorneys, essentially. Here, everyone was essentially a general practitioner in the New York bar in the 1780s and 1790s. So Hamilton would be doing contracts and land disputes one day, and then going to court on a criminal matter the other day. But the cases that I want to talk about cover the span of Hamilton's career, from when he first entered the bar until just before his death. So I'm going to talk about 3 different categories of cases. First, Hamilton's war cases, which he worked on in the early 1780s, right when he started as a lawyer. Second, I'll be talking about the Manhattan Well murder case, in which Hamilton, Burr, and Livingston teamed up as co-counsel. And lastly, I'll be talking about libel cases that Hamilton worked on, most famously the People versus Croswell, which he argued the year of his death in 1804. Now, at the end of the war, New Yorkers were extremely angry at the British occupation. They really felt that the British had taken a toll on their city, and the New York State legislature wanted to essentially get revenge. So they started passing a series of anti-Tory measures starting at the end of the war. This included the Forfeiture Act in 1779, and the Citation Act in 1782. And the purpose of these acts was basically to strip anybody who supported the British of their wealth, and to make sure that if patriots owed loyalists money, that those debts would not be honored. And the most extreme of these anti-loyalist measures that the New York State legislature passed was the Trespass Act, which was passed on March 17, 1783. So it was called an act for granting a more effectual relief in cases of certain trespasses, which it essentially meant the purpose of the law was that if someone had suffered damage, so this created a cause of action for wartime damages. Essentially, like if you had a business or you had a home that had been taken over by the British during the Revolution and given to someone who supported the British to run that business or live in that home, that person whose home or business had been taken over by the Loyalists would have a cause of action to sue the Loyalists who had occupied their property. Now, on Evacuation Day, November 25th, 1783, when George Washington came into New York with the Continental Army, tons of people who were Loyalists fled. You know, they went back to Britain, or they left New York. And Hamilton was very concerned about this because he thought that the Loyalists were an important part of New York society and the New York economy. So in August of 1783, a few months before Evacuation Day, Hamilton wrote to James Joint that we have already lost too large a number of valuable citizens. So even though Hamilton had fought in the war and was part of the Continental Army, he wanted the Loyalists to remain in New York because he believed it was important to integrate them back into the society so that for the economic well-being and general for New York to kind of move on from the war. So into this equation, we have the Rutgers versus Waddingham case, which was one of the most famous cases that Hamilton did as a young lawyer. So he's, at this time, he's 2 years into his practice. This case happens, and it's a very high-profile case. It involves this very sympathetic widow named Elizabeth Rutgers, whose brewery was taken over by a British merchant during the war. And he had occupied the brewery and essentially was running the brewery for a few years during the war. And so poor widowed Mrs. Rutgers tries to sue the British merchant that had taken over her property during the war and get monetary damages for his occupation period under the cause of action provided by the Trespass Act. The plaintiff's legal team was full of prominent attorneys, including Robert Troup, who had been Hamilton's roommate and also who had lived with Burr, and who had really helped Hamilton study for the bar. And there was Egbert Benson and John Lawrence, who I will not speak too much about. But this was considered a very, very sympathetic case. You know, everyone was expecting that the Mrs. Rutgers would succeed in her claim. And Hamilton took on the bulk of work for this case. He wrote 6 trial briefs, and he is the one who actually did most of the arguments. And this case was also important because Hamilton argued based on the principles of international law. Essentially, he argued using the philosophy of Grotius. Hamilton argued using principles of international law that because the occupation had occurred while the British military was occupying New York, that it should be that there should not be a cause of action because the Treaty of Paris, which had ended the war, had kind of resolved the issues between the U.S. and Britain. So for a state to come in and say that there's a cause of action that even though these actions were justified under the British rule. By the British military rule, there's still a cause of action against private citizens. Hamilton believed it was a violation of the Treaty of Paris and of the principles of international law. This was one of the earliest cases involving the principle of judicial review, which is very important to the Supreme Court today, that courts should be able to consider whether a statute is valid or not. And the legislature does not have absolute power to pass statutes that are not consistent with what the federal government decides. For example, here Hamilton argued that because the Treaty of Paris should control all relations that stemmed from the war, that the New York statute violation of the Treaty of Paris, and thus should not be permitted to stand. Now Hamilton actually argued over 60 cases in the so-called war cases involving the Trespass Act and the Confiscation Act. And in every single one of these cases, he defended Loyalists. Gave Hamilton, this helped contribute to Hamilton's later lifelong reputation as someone who was a sympathizer of the British. and it really brought a lot of bad will to him, but it also gave him a lot of publicity and really made him a prominent member of the New York bar. And interestingly enough, Hamilton and Burr actually were co-counsel on one of these War Act cases. On January 27, 1786, they both argued as co-counsel against extending the Citation Act. So that's actually pretty interesting because it's not very well known. It's not a very well-known case, and there's not much material out there. But Burr actually was one of the lawyers who argued both sides of the war cases. Essentially, he didn't have a bone to pick with it, as far as we know. He would take cases. He would defend loyalists, and he would take cases from patriots who were trying to prosecute. So this is the 1780s and 1790s, kind of the early period of Hamilton's practice. And this Hamilton kind of comes out charging. He takes on a very prominent Rutgers versus Waddington case, and he is nonstop with these kind of cases. He's very clear on his position, and he only takes cases here with the war cases that follow his political position. That essentially these trespass and confiscation acts are not good for New York. Now we move on about 20 years later. Now this was held in over where Federal Hall is now, and apparently it was extremely crowded. They said that on the morning of the trial, the concourse of people was so great as never before witnessed on a similar. It really drew the attention of the people of New York. The suspect's name was Levi Weeks. His brother had worked on Alexander Hamilton's house, Hamilton Green, and Levi Weeks had also worked at that house. So his brother was a pretty prominent architect, and so Levi Weeks was able to gather kind of a dream team of defense lawyers. But this is of interest for legal historians because it's the first recorded murder trial in American history, meaning that we actually have transcripts of this trial that were written down, because it wasn't common practice to actually transcribe what the witnesses were saying. Records of the final judgment prior to this, but they wouldn't, and they would sometimes keep copies of what the lawyer said if there was a prominent attorney. But this case, we have a fairly complete record of all the witnesses that spoke at the trial, and so we kind of have a sense because of this case as to how a murder trial worked in 1800 in New York. And you can kind of see what all the witnesses said and how those rules worked. But the reason that it was actually the first recorded murder trial was because the murder drew so much attention. It was all over the newspapers in New York and was republished outside of New York as well. So we have, if you remember, a young Cadwallader who, from the beginning of my talk, he's the prosecutor. And at this time, he's older in this picture, but at this time he's 31 years old. He's the only prosecutor in this case versus 3 very prominent defense attorneys. So the way that criminal law worked, or criminal cases worked, is that the jury didn't get a break. So they very rarely went more than a day, but the jury would just be expected to stay they were physically locked into the room. They couldn't go home at the end of the day. And so they referred to them as like the other prisoners because in the court, because they really just were stuck in the jury room. And so the judge in this case said, we need to move through these witnesses as fast as possible. And then we have the defense team, which consisted of Aaron Burr, Alexander Hamilton, and Brockholst Livingston. So essentially a real dream team of prominent attorneys in New York. And Brockholst Livingston did this basically for a living. At this point, he was one of the most seasoned criminal defense attorneys in all of New York, probably all of America. So he had taken on essentially every major criminal, like I said, every major criminal case where the defendant had enough money to hire him, he would be the defense attorney. On the other hand, this was Burr and Hamilton's first real murder trial, but they were hired because of how prominent they were. And here's where I think it gets interesting. During the trial, this whole case is very interesting, and I've done a talk just on this case. So this time I'm just focusing on kind of the relationships between the lawyers here. So although Brockholst Livingston was, the most seasoned in terms of this area of law, he hung back during this case. And everyone agrees that it was Aaron Burr and Alexander Hamilton who did almost all of the talking and arguing and examining of witnesses. Who actually came up with the defense strategy, we don't know. I would guess, based on the way that this trial was conducted compared to other criminal trials, it was probably a lot of Livingston's strategy. But during the case, the prosecution kind of put forth a lot of theories about the victim. So they would say that the victim was suicidal, so they had tons, not the prosecution, the defense lawyers. So they had a lot of people talking about the defendant being moody, and then they had people talking, they just set up tons of alternate theories of the crime, the way that we would do today or you see on TV. So they set up like 6 different theories, and they had about 45. Hamilton and Burr would just go, they would take turns doing these witnesses. So we don't know what Burr did versus what Hamilton did. But conveniently, they both separately took some credit for what was considered to be the most dramatic event during the trial. So during the trial, there was all the people that were involved with the case lived in a boarding house together. So the defendant lived there and the victim lived there. And there was another person who lived in the boarding house who was later handing out flyers, essentially handbills, saying that the defendant was guilty. And so this guy, Richard Croucher, was kind of a shady character. He was not good to look at. He looked criminal, squirrely. And so there was this one moment where someone was saying that they identified Levi Weeks, who was the defendant, and Hamilton or Burr initiated this line of questioning, basically like how dark was it? How sure are you that you saw this person? Like the standard questions that you'd ask to destroy eyewitness credibility. But the witness acknowledged that it was dark, you couldn't see it was shadowy, the man was in the shadows, and then Hamilton or Burr says. Holds up a candle or lantern very dramatically, because this was at like midnight during the case, and says, "Are you sure it was Levi Weeks, or could it have been this man?" And so he points the candle in the direction of Richard Croucher, who's sitting in the gallery, and then the entire jury just focuses on this other guy, on Croucher, and that was a moment that was very, very heavily reported in the newspaper as being the moment where people's suspicions shifted from from Levi Weeks to this other guy, Richard Croucher. And so Hamilton and Burr both said that they were the ones who had come up with the idea and also held the candle. And we don't actually know who did it, and if that moment was as dramatic as the newspapers reported it to be after. But it was a very key moment of the case that both Hamilton and Burr later claimed to be their ideas. So the outcome of this case, the Manhattan Law murder, was that Levi Weeks, the defendant that Hamilton, Burr, and Livingston were representing, the jury retires, and then 2 minutes to 4 minutes later, depending on which account you trust, 2 to 4 minutes later they come back and they all say not guilty. So the last category of cases that I want to talk about, I think, were some of the most personally important to Hamilton, and that's cases involving libel. And at this time, we had the First Amendment, but there were still laws about libel that prohibited people from slandering others. And under the common law of libel, as it was applied in England, it did not matter whether or not that statement was true. So if you slandered someone and it fell under that definition, even if your statement was true, you could still go to jail for criminal libel. The first case I want to talk about is called the People versus Frothingham. And that's a case that Hamilton was involved in, but not as an attorney. He was the person that was the victim of the criminal libel. So this case happened in the end of 1799, but this was just before the Manhattan Law murder trial. So in this case, Hamilton was responding to something that had been printed about him in the New York Republican newspaper called the Argus. And so the Argus printed a letter that insinuated that Hamilton had tried to secretly purchase this Republican newspaper in a different state using money from an emissary of the British king. It insinuated that Hamilton was having secret meetings with the British and was using British money to try to buy up all the Republican newspapers in the country. And Hamilton was very outraged when he read this. So he reads it, it comes out in the very early November, and he immediately writes a letter to the New York Attorney General. And he insists that the printer, in his letter, he asks that the printer of this publication be prosecuted for libel. And so at the end of November 21st, 1779, that printer, David Frothingham, was was indicted on this charge of libel. And on both sides, we have two people that we should, familiar people. The prosecutor was Cadwallader D. Holden. The defense attorney was, of course, Brockholz Livingston. And so Livingston tried to make his twofold argument. First, he argued that they had the wrong guy, essentially. That David Frothingham should not be, he was just a journeyman, kind of. He wasn't the owner of the paper, and that if they're going to prosecute anyone for libel, it should be the owner of the paper. And then he also argued that the statement was not false, essentially, that it wasn't libel, and it also was not false. However, the common law of libel did not require that the statement be false. So Hamilton actually petitioned to the court. He wanted to testify, and he had an extensive defense prepared of why the statement was so outrageous, because it was not true, and he didn't have these secret meetings and try to buy up all these Republican newspapers. So he wanted everyone in the court to kind of know that the statement wasn't true, that was something that was very, very important to him. However, the court said no, the truth is not an issue in this libel case. It's just whether the statement was libel. And to the court, it didn't matter whether, it wasn't an issue at all, whether the statement was true or false. So you can see where that would have some conflict, natural conflict with what we think about the First Amendment today, right? Because if you're not free to say things that are true, then what is freedom of speech? And how does that actually work? So Frothingham was convicted, the statement was found to be libelous, but because people felt bad for him, he received a very lenient sentence, so it was really like a slap on the wrist. But it was interesting because Hamilton and the country and New York and the courts were struggling over this clear conflict between common law libel as it was understood by the British and had been interpreted by the New York courts, and what the First Amendment permitted in terms of freedom of speech. And Hamilton very strongly believed that truth was the most important thing. To him, that's really what mattered, that he wanted to say that the statement should be criminally prosecuted because it was not true, not because it was part of the common law of libel. To him, the truth or falsity of statements about his reputation was what he was concerned with. So let me move on to this case called the People versus Croswell. It was Hamilton's last major case, and it was an appellate case that he argued in February 13th of 1804. So Hamilton had taken over this case from William P. Van Ness, who had initially argued it in the lower courts. And the printer's name was Harry Croswell. He was this young printer in New York, and he had written a lot of statements in his newspaper called The Wasp. He had written all these statements about Jefferson and how Jefferson was the worst and Jefferson was corrupt. He lampooned him. He lampooned every Republican, every major Republican essentially. And at this time, partisan politics and the press were out of control. So it was like a press war all the time. So everyone was writing statements about everyone. And now that the Republicans were in power, they started to prosecute libel, criminal libel cases. And so once they had lost the case, this guy Croswell wanted to appeal it. So Hamilton takes over as lead counsel during the appeal, and he's still working with William P. Van Ness. And that name might sound familiar to you guys because in the duel between Hamilton and Burr that happened today, William P. Van Ness was Aaron Burr's second, and he was an ally of Burr. But so Hamilton's argument was intense. Like, it was a packed courthouse. People actually took a day off. Even the New York State legislatures took time off to hear his argument. It was very eloquent. It lasted for 6 hours. So he argued in this. This is where Hamilton kind of comes to terms with really what he believes the First Amendment and liberty of the press to mean. So he says the liberty of the press consists, in my idea, in publishing the truth from good motives and for justifiable ends, though it reflects on the government, on magistrates, or individuals. And he said, the right of giving the truth in evidence in cases of libels is all important to the liberties of the people. Truth is an ingredient in the eternal order of things, in judging of the quality of acts. So this is exactly what he had tried to do in the Frothingham case, but was not permitted to do, right? So the courts, when they were hearing common law libel, truth of the statement was not an element of that charge. So no one paid attention to whether it was true or not. It was not part of that equation, which is the way it actually was in Britain until very, very recently. So Hamilton's speech was 6 hours. It went for 2 days. And everyone gathered around the courtroom. Like, people came from all over to hear him talk. And one of the justices, Justice Kent, stated, "A more able and eloquent argument was perhaps never heard in any court." So what happened, there was five people on the appellate panel, but one of the five, named Ambrose Spencer, had actually prosecuted the case when it was at the lower level. So he had to recuse himself. He wasn't able to decide because he had a bias, right? He was previously the prosecutor. So the judicial panel split 2-2. So because it was deadlocked, Croswell actually, the conviction stood. So it was a case that Hamilton kind of lost, right? I mean, his argument convinces two of the justices, but because it's a tie, the conviction stands, and he's not able to help this individual. But the case has an extremely major legacy in New York. It happens in February 13th of 1804, and immediately before this, there had actually been a bill under discussion for permitting truth to come into evidence for libel, and then this case and the effect kind of had a big effect because the legislatures, they all took that holiday to come watch Hamilton, and they were all pretty convinced that this is the way that the law should be. And so the statute finally passed April 6th of 1805, and it was submitted by William P. Van Ness. So this was after Hamilton's death that the statute passes. And it says, "And be it further declared and enacted, that in every prosecution for writing or publishing any libel, it shall be lawful for the defendant, upon the trial of the cause, to give in evidence in his defense the truth of the matter contained in the publication charged as libelous." So this is exactly what Hamilton had asked for, right, and very eloquently argued for 6 hours. The Constitutional Convention of New York in 1821 added that in actually to the New York Constitution as Article 1, Section 8. So in the part that discusses free speech, it says, "In all criminal prosecutions or indictments for libels, the truth may be given in evidence to the jury. And if it shall appear to the jury that the matter charged as libelous is true and was published with good motives and for justifiable ends, the party shall be acquitted." And so if you look at here what Hamilton said, he says, "The liberty of the press consists in my idea in publishing the truth from good motives and for justifiable ends." So even though Hamilton lost the actual case in People versus Croswell, he's definitely part of the legacy of that case in moving New York forward and away from that, the common law of libel, into something that considers truth and evidence. And that's a big part of truth, and the ability to freely state something that's true is a big part of why the press is free, right? And it's something that separated America from the British system. And New York libel cases and that New York libel statute that was passed in 1805 also helped the country define the First Amendment and what this freedom of the press actually meant, and how to apply that, and how all of those things interacted. That wraps up my talk. I think that generally the takeaway of this was that through the lens of Alexander Hamilton's cases, we focused just on 3 types of cases, and he had tons and tons of cases. Like his legal career, he didn't spend that much time practicing law, but his career was very varied, and we could have had a whole hour discussion just on his insurance and land dispute cases time. And the New York bar and the relationships and the way that they were able to shift alliances really had an impact on New York law at that time, and also on American jurisprudence in the long term. Thank you for coming.